SJC-11731, Commonwealth versus Gonzalez.
Mr. Shaw, good morning.
Chief Justice Skansen, may it please the court, my name is Robert Shaw. I'm privileged to appear this morning on behalf of Clarice Gonzalez. My intention this morning is to address what we assert is insufficient evidence to convict Clarice Gonzalez of first-degree murder. I also hope to reach additional issues which, as the court knows, are intertwined with the sufficiency analysis. And I hope to close with a few comments about this court's 33E review. And before looking at the evidence and what is there, and importantly, what is not there.
Could you, what year was the trial? I know I should know this, but
2013, July 2013, Your Honor. I want to address and acknowledge what the standard is. The test for sufficient evidence is not, it cannot be, can the government, despite significant gaps in the evidence, come up or construct a narrative of guilt. There has to be specific evidence, and here that specific evidence has to provide a foundation to prove that Clarice Gonzalez participated in and premeditated this killing. And that foundation of evidence needs to be sufficient, as you know, to exclude all reasonable doubts. Now, when we look at the evidentiary context and the specific evidence upon which this conviction is based, I suggest to you that there is insufficient evidence. Contextually, you know that Clarice Gonzalez worked for her father's car dealership. She was doing some paperwork chores on January 10th when this killing took place. You know that she sold a car to the victim.
I'm sorry, I thought she said that she was on her way to Calixto's house.
Well, there are many things she said in her statement, but during that day, she was going to the car dealership to get some paperwork for her father. You know she sold a car to the victim. There is no evidence before you that that transaction was other than a routine arm's-length transaction, and there is no evidence before you.
well, I don't know what the evidence was, but there wasn't there evidence that the payment wasn't complete?
Sure, but I'm talking about the
You mean
transaction
the actual
itself.
transaction
Yeah,
itself,
that it was a routine transaction. And there's no evidence before you that before Joelle Javier, her boyfriend, was involved, that there was any sort of conflict, any sort of dispute, any problem that she had with the victim because of a small amount of money that was owed.
What about the phone call at 2 o'clock in the morning?
Right, and I'll get to that, Your Honor. I'll definitely get to that. But just contextually, before we get there, I also just want to point out, because I think this is important, it's certainly important for 33E review. Clarice Gonzalez this isn't a case that involves gangs. Clarice Gonzalez has no criminal history. She's 19 years old, okay? And you also have evidence in the record that described her. Her demeanor is somebody who was shy, quiet, insecure. I think that's important contextual evidence. Now, looking at the specific evidence, what allegedly led to this killing, and what we know about the killing itself. Clarice Gonzalez tells the police, and I don't think the Commonwealth disputes this, at page 4 of their brief, they seem to affirm it. They're driving around early morning hours on January 10th. They apparently see Mr. Gonzalez, the victim, also driving. A call is made to Mr. Gonzalez. That call is made from Javier's phone, okay? There are a series of calls between 2:11 a.m. and 2:17 a.m. that are between Mr. Gonzalez and Mr. Javier. There's also a call from...
Am I right that there was an attempt at a call from her phone, and then she used his?
There's no evidence that that actually took place. And I'll get to that in her statement. She says that she's uncertain about how this whole thing
But I mean, you had the
happened.
call records.
It's not, no, there is no evidence in the call records that that ever happened.
Okay.
Okay? It's not, there's no evidence that that happened. Okay? These are between Mr. Javier's phone and Mr. Gonzalez's phone. Okay?
She was with Mr. Javier.
That's correct. She's driving a car.
Who was driving, do we know?
She was
She
driving.
was.
She was driving
She
then.
was driving.
But her statement, she spoke to the, right?
She said that she spoke to him. That's what she said. okay? And we can get to that.
There's
That's-
evidence
that's
that
what
she
said.
did, yeah.
Well, that's what she said, right, but not from calling from her phone.
Okay.
Okay? Now, this unfolds rather seamlessly into them being in the same proximity, windows getting rolled down, and yelling taking place. Who's yelling? It's Mr. Javier, it's Mr. Gonzalez, okay? There's also, by the way, a call from Mr. Gonzalez's phone to Mr. Javier's phone at 2:32 a.m. that you'll see at least in the cell tower records. So do we have any evidence that Carice Gonzalez was involved in a heated, as the Commonwealth says, argument? No, we don't. Do we have any evidence that Carice Gonzalez initiated some sort of confrontation? No, we don't. Well, we know that a physical confrontation took place. Was Carice Gonzalez involved? No, she was not involved. Mr. Javier was involved. The witness who was there, the Commonwealth's witness, says that Carice Gonzalez was a peacemaker. She tried to get him to leave, okay, to diffuse the situation. The next day, they run into Mr. Gonzalez again. What does Carice Gonzalez do? She tells Javier to hide in the back because she wants to avoid a confrontation. When they end up at Javier's house and Mr. Gonzalez is there, and that's either because Mr. Gonzalez knows where Javier lives or because he followed them there. And by the way, Mr. Rosario, the person who was with Mr. Gonzalez, knows Mr. Javier. He says that. He knows him well. I think the court can infer that Mr. Javier knows Mr. Gonzalez. Now, there's nothing in the record about their history, but I think that that's rather clear, that these groups know each other and that there's perhaps a history there.
Can I ask you, and Mr. Javier was also convicted of murder.
That's
right?
correct.
First-degree murder. Was his trial before or after?
After.
Okay.
Now, so the next day, what does Carice Gonzalez do? She says, get in the back when they show up at the Javier house. She says, leave. Now, why would Carice Gonzalez do that and stay at that house? Is it because she's going to go onto the front lines and engage in a confrontation herself? No, it's because the confrontation involved Javier. It did not involve her. And what does she do? She runs to Javier's mother. She says, a man wants to beat up Joel. She says it's scared. Why would she say that? A man wants to beat up Joel because the confrontation is not her confrontation. It was his confrontation. Now, let's look at what we know about the killing and where it took place. We know that it is approximately 1 mile to her father's car dealership. It's approximately 1 mile to Javier's home. It's much less, the testimony is, 2 miles, much less than 2 miles to Carice's home.
I thought that, is that where she, no, and I'm sorry, I was getting confused. Okay.
That's
So it's
Cali-
much
it
less
was-
to her home,
it-
and then
four-
Calixto's home, I
was
think.
4 miles to
4 miles
Calixto.
That
to
was
Calixto's
to
home.
Calixto's home.
Okay, and in terms of with regard to the T-Mobile records, which I know you challenge its admission, but putting that aside, was there any evidence as to the specificity of when they say that it was at or about the location of the killing, did the range include her home or her dealership in terms of where she could have been?
Well, it's just basic that a mile is within a range of a cell tower, as noted. I mean, it's very understood.
But apart from what's understood, was there testimony in this sense as to when the person says they're in this location, was there a sense as to what the...
No, he didn't provide detailed information about the coverage of
Was
each of
was
these.
the evidence that all the places you've mentioned are within the circumference of a circle around that cell tower?
He didn't even get into that, as I recall. He didn't even get into that. I mean, McDonald, who was their expert, didn't even have enough personal knowledge to know how far away the towers were from each other. I indicate that and point it out in my reply brief, which I'll hope you'll look closely at, okay? And I have a couple points about that, but just to move back, now that we've sort of addressed Justice Gantt's question, I want to assume for purposes of this analysis, and I don't concede it whatsoever, I want to assume for purposes of our discussion that the video showing this van is Carice Gonzalez's mother's van, okay? And I want to do that because I don't have enough time to address every scenario with you, and the fact is that even if it is that van, there's insufficient evidence. Because what do we know? We know that Joel Javier drives that van. We know that the night before, he's at Barbara Delgado's house. Someone testified he was carrying the keys in his pocket. He pulled them right out when someone wanted to go to the liquor store, jumped in the car and went to the liquor store and left Carice behind there. You have the Commonwealth's witness who says that in the past he's seen Joel Javier driving that vehicle around.
But, I know you're telling a narrative, but the fact, I mean, are you saying Javier was driving and so Javier was not one of the four who got out of that car?
All I'm saying is that even if we assume that that was her mother's vehicle, that does not implicate in any way whatsoever Clarice.
Now, with regard to Calixto's testimony, did she say which car they drove to get there?
It was the van.
So Calixto says that Clarice was in the van.
Well, I don't think she's aware of Clarice being in the van, but it is the van.
But how do you know it's the van?
Well, because Clarice doesn't deny that she went in the van over to Calixto's house.
And does Calixto say that Javier is with her?
Yeah, there's no doubt that they're together.
So
at that point
Javier
in
and
time.
she are there, and was
Right.
there any testimony as to demeanor of either of them at 6:09 p.m.?
Well, it wasn't well, we don't know whether it was 6:09 exactly, but their demeanor appeared to be normal. Yeah, she said there was nothing odd about it
Not
whatsoever.
6:09.
And I would also note, if you
I
look
thought
at
there was a telephone call between Calixto and Clarice's cell phone
At
at
6:09
6:09, at which
right.
Clarice said, I'm outside.
That's correct. She told the police that, right. And then,
But but Calixto told the police that Clarice said, I'm here, basically, right?
basically, yes. And then at a later time, she said she thought it was 6:15 or 6:20, so she contradicted herself.
But we can infer, at least the evidence would permit us to infer, that she was there at 6:09.
Well, you could potentially.
sometime before
infer that.
6:09 when
That's
she was there.
correct. But when you're dealing with this close proximity and location, let's just assume, again, because we're assuming this, I'm not, for purposes of discussion, let's say Joel Javier was in that van at the time of the killing. How long would it have taken him, if he's going 30 miles an hour, to drive 1 mile and pick up Clarice and say, let's go to Ashley's? 2 minutes? 3 minutes? Okay, so it doesn't show anything. And the other important point here is we know that Joel Javier is using Clarice's telephone. The detectives know that, they admit that. There's really no doubt about that. His phone was destroyed when this confrontation took place. He's using her phone, he's using her car. That is what the evidence is. And what do we know about the alleged co-defendants in this case? The alleged co-defendants in this case are Joel Javier's co-workers. They're Joel Javier's friends. I think Stackerman and he would refer to each other as cousins, but that's what it is.
But in terms of sufficiency, though, she says, I was with Javier all day.
Right, and I think you can infer.
So isn't the jury permitted to accept that as true?
Well, Your Honor.
I mean, I know you may argue that maybe she was trying to protect Javier, but if we're viewing in the light most favorable to the Commonwealth, don't we have to accept that the jury was allowed to believe that?
I don't know that it's reasonable to think that that means she is with him every minute of every day. That when she goes to a car dealership to do some paperwork chores, that he's following behind her, for example.
Well, if she says, as I think she did, I was with him all day, the
Right.
jury is permitted to believe that.
I think the jury is probably permitted to believe that, but I still don't think that gets you to a conviction of first-degree murder. Yeah, no, I understand. And I think the other point that's important about her statement is that if you look at her statement, I think it's clear that she wants to protect him. I mean, it's very clear that she wants to protect Joel Javier. But what's also clear is that she doesn't know enough to tell the police an alibi that would get her off the hook. They say, well, where were you between 5:30 and 6 o'clock? And she says, well, I was probably getting there or in the process of getting there. That doesn't help her in any way whatsoever.
What time did the murder take place?
About
5:57?
5:57 or 5:58.
And we know that because of the videotape, or we know that?
Well, that's what the police say, the videotape is a slightly 4 minutes later.
Yes, but I mean, the time frame is established primarily by the
And then there's a 911 call as well.
911 call.
Right.
Okay.
So the other thing is that when you look at what she's doing, I mean, she's really conducting herself as somebody who is unaware. I mean, what does she do after she goes to Calixto's house? And let's just assume, again, for purposes of discussion, that the van was involved. She leaves Joel there after about 20 minutes. She hops back in the car alone and goes driving around. She goes and picks up her mother. Then, when the police want to speak to her, what does she do? She drives the van to the police station. She is conducting herself as somebody who does not know enough to calculate and to assist herself. Now, I think the bottom line here is that there is no evidence in this case that Clarice Gonzalez planned a killing. There's no evidence that she spoke to anybody before this killing took place about a killing. There's no evidence that she drove a vehicle. And even if you were to make the unwarranted assumption that she was driving that vehicle, there's no evidence concerning how that came about. There's no evidence concerning who was in that car. There's no evidence concerning whether when this thing happened and the van stopped, that was random or intentional or planned. If it was random, how would she know what was going to happen? How would she know that two people in the car were armed? How would she know that it would result ultimately in a
If we
shooting?
can go back to Miss Calixto again. What was her testimony as to what plans did she expect? Ms. Gonzalez and-
Clarice had spoken to her earlier in the afternoon. She had just had surgery, and that, yeah, we'll come by sometime tonight. 1 or 2 o'clock, there was a call.
Okay, but there was no time set for when
Not
they
a
would come by?
specific time. No, there was not a specific time.
But Ms. Calixto said that they had called and she expected them to come.
At some point, yeah. What are you doing? Yeah, she had just had surgery. We'll come and visit you. Okay? Now, looking at the cell phone evidence again, you can't properly conclude anything, as I've indicated, by the cell evidence. McDonald's testimony doesn't change that. He didn't have personal knowledge about that network. He didn't know how far the towers were. He's really talking in abstractions and saying, well, this is what would typically happen. The second point about that is that the Commonwealth says, well, there was a call from the 1836 number to Castro's telephone line at about 6:01 p.m. Now, does that mean anything? Not really, because everything's in such close proximity. But let's just assume that Mr. Javier has the phone, because we know he has the phone, and he's there. Again, how long would it have taken him to go from there 1 mile to where Clarice is located?
Is she located on the way to Calixto's house?
Well, her Methuen home would have been on the way to Calixto's house. And Joel Javier is, a mile away, his house, and the car dealership is also a mile. I mean, very, very close. Now, let's look at the video evidence.
I'm sorry, the direction of the van before it stopped headed towards Methuen or not? On Haverhill Street?
I'm not sure I'm capable of answering that, Your Honor.
Was there evidence about direction and location? Were there maps
I
in
don't
this
think
case?
it's, not really. I think there are maps involved, but again, I mean, a car could always,
Obviously, a
turn
car can
around.
turn around, but
Right.
That three-point turn.
right, but it could also turn around, anything could happen after that, right? It could go in any
no,
direction.
it's not a matter of what happened after. It's what happened before, where it was headed. I mean, there were 4 people in a.
Yeah, I don't know. I don't know. With respect to the video evidence, very quickly, this very impressive FBI expert comes in, and this must be a scientific and disciplined analysis, right? Because that's why we had an FBI expert come in. So what scientific conclusion can he provide? No conclusion.
Was there objection to his testimony?
There was not. There was not, but there should have been.
And you claim ineffective assistance, but there was no evidence presented at a motion for new trial?
Right. I'm saying that.
Why not?
Because I think that it's obvious on the record that when you have somebody come in and provide a videotape that starts taking, well, there is no identification with this van, but we're going to take Clarice Gonzalez's mother's van. We're going to put it at the crime scene. We're going to put it on a video, and then we're going to fade in and out and in and out. Is there an identification here? No, but we're going to do that. Why? Why would you do that? That's totally prejudicial. It's inconclusive evidence. It must be scientific. The scientific conclusion is that there cannot be a conclusion. It's like taking a defendant when there's no identification, but telling the jury, this is a picture of the defendant, and look, we're going to put him at the crime scene, and we're going to keep fading in and out. It's more prejudicial than probative, and I think that it is obvious.
But what reasonably could be taken from that testimony? That it was a Dodge Caravan?
Well, I think
Or-
that it's trying to persuade the jury to make the inference and to say, yes, that it is, and it is Clarice Gonzalez's mother's
Same
vehicle.
make? I mean,
Yeah.
it's a Dodge Caravan?
It did appear to be the same, but of course,
How about color? Is there anything about color?
there's no color on the video that can be indicated. But again, when we look,
But doesn't he say, I thought that the person testified that he matched color, make, whole bunches of things that sort of matched up together.
their general class characteristics,
color
color
isn't
wasn't
one
one
of
of them. Color wasn't capable of being seen. And of course, we know that the victim's vehicle was also the exact same vehicle. You could have driven the victim's vehicle at that time of night, at that same path, under that
But the
artificial
victim's
lighting.
vehicle, we know where that was.
Right, but I'm just saying, it's the same kind of vehicle. So they could have taken that vehicle and driven it on that path and faded him in and out, and presumably it would have been the exact same thing.
But I'm trying to ascertain what reasonably could be taken apart from the fading in and out. Is it simply that it was a Dodge Caravan? Was it that detailed?
Couldn't exclude it.
It looks the same. It looks the same. He couldn't, well, that's his testimony. I
I'm
cannot
sorry, that's what
exclude them.
I'm saying,
Yeah,
that's what
yeah,
I'm saying.
Yeah, I cannot exclude them as being the same, which to me is, I had to review that several times to process that. I can't exclude them as being the same. It presumes that we start from a position of they are the same. That's not proper scientific testimony. It violated the guidelines that he should have been following. In closing, Your Honor, I simply want to say to the court, what I am asking the court to do under 33E is to use what I suggest to you as common sense, what I suggest to you is your experience that I know you have to recognize that in our society, in our communities, in the way we interact as human beings, in the way that 19-year-olds act, there are a variety of circumstances in this case. There are a variety of ways that this could have unfolded that did not involve Clarice Gonzalez at all. And because of that, what I want you to do is I want you to find that there's insufficient evidence under our traditional legal standard. But if you can't do that, what I'm asking you to do is to do it under 33E, because that is your obligation. And I suggest to you that what happened here in this conviction is not a just conviction. Thank you.
Thank you.
Good morning. May it please the court. David O'Sullivan for the Commonwealth. I'd like to begin
Bookending
with...
our week, Mr. O'Sullivan.
Yes. The sufficiency claim, of course, is judged under our familiar Lattimore standard, which requires that the evidence be viewed in the light most favorable to the Commonwealth, and all the inferences that are reasonable, though not inescapable, must be drawn in the Commonwealth's favor. My brother's presentation of the evidence, of course, adverts to inferences that the jury may have drawn in the defendant's favor, but did not. Of course, the court views the evidence in a different light. And I'm aware that the court, of course, will have the exhibits, and I'd like to go through the evidence implicating the defendant in this clearly planned execution of Robert Gonzalez. The first would be Exhibit 33, which would be the videotape, or the compiled videotape of the surveillance video taken from across the street of the site of the murder. And as the court views the videotape, it will see that it doesn't permit identification of human features, but it shows that at the...
You know how many people are in the car?
there's
There are five. It
Yeah.
shows five.
It shows five. Five are definite based on a driver remaining in the car after 4 alight from the car.
And so it's clear that somebody is still driving after 4 leave.
Because immediately after the 4 alight, the car turns down Forest Street, does a maneuver, and a 3-point turn to go back down Forest to Haverhill Street, takes a right to ultimately go in the same direction it was originally traveling, even though Forest Street is not.
I'm sorry, would you do that again? It goes...
Sorry. So at the intersection of Hampton Street, where the victim's car was, and Haverhill Street, on the other side of that intersection is another intersection with Forest Street, which meets up with Haverhill Street. After letting off the 4 assailants at Hampton Street, at the intersection with Hampton Street, the caravan takes a right on Forest Street, does a 3-point turn about a few hundred feet down the road, and then goes back. inferably, as the prosecutor argued, to permit time for the four assailants who had walked with purpose directly toward the victim's car, didn't meet or talk, apparently, after they alighted from the car, to permit time for them to carry out the shooting and to permit time for the caravan to meet up with an adjoining street in the direction where they were seen to have gone on the videotape. So I would submit that the videotape will permit a strong inference that the driver of the caravan, whoever it was a knowing participant in this planned execution.
So when they left the car, were their guns showing?
It's not, it's too grainy to see that close. But they walk directly across the street and make traffic stop for them directly toward the car, walk toward its back, car lurches forward, the shots are fired.
I didn't understand the lurching forward. That's before a shot, correct?
Unclear from the videotape, as you'll see, they reach the back of the car lurches forward. There's a person in the foreground who ducks in response, but it's impossible to tell whether the lurching occurs before or after, but the lurching occurs when they've reached the back of the minivan. So it's unclear whether it was in response to shots having been fired or an attempt to get away, but as you'll see, that's unclear.
But it doesn't look like that was provoking.
No, Your Honor. I mean,
It wasn't
I
like
think
somebody was walking in front of it and the van lurched forward in an effort to run somebody over.
no.
That's not
and
what it shows.
That wasn't a theory the defense presented at trial as a sort of, they didn't seek an instruction on provocation, and none was given.
Now, the car of the killers stopped on Haverhill Street, but the other car was not parked on Haverhill Street. It was just parked just off Haverhill Street. It was parked on Hampton Street.
That's correct. Right at the intersection, right before its
Are they,
intersection.
are
with-
they perpendicular to each other?
They are, Your Honor, and there are maps in evidence, particularly Exhibit 80. Well, there are several maps, and I may get this exhibit wrong, but I believe it's Exhibit 43 or 44 is a map of the area, but there are several maps that you will see, and a chalk as well, detailing both the configuration of the streets in that area and the broader area with regard to the cell towers.
And there's no evidence as to what those folks were doing. We have none of the four testified on behalf of the Commonwealth. You had no cooperating witnesses here.
Correct, Your Honor.
So, is it clear that you could see that car from Haverhill Street? You could see the other van?
Yes, so there's definitely an inference that when on Haverhill Street, the car passes the intersection with Haverhill Street, it slows and stops, inferably upon seeing the victim's car there. So moving on to the evidence that the Commonwealth needed to present with regard to was the defendant the driver of this car. And that evidence is easily permits that inference as well. First, with the FBI agent's testimony, Agent Smith, that from a video analysis and a recreation of the path of the car using the car.
But what if the video analysis is really a real problem?
The video analysis wasn't objected to, and I would submit it was properly admitted, notwithstanding the fact that it couldn't permit an identification. It's similar to
What could the, given that it couldn't permit an identification, and it seemed to, I may have this wrong, but he seemed to say there's three things I could say. It is the car, it's excluded, or it's inconclusive or something. There was some word in the middle.
inconclusive in the sense that it is not an individualization.
Okay. So what is he adding that somebody who, the jury can't do by themselves?
Well, he, through an analysis, determined that the so-called class characteristics of the car, and he specified what those were: the size of the car, the shape of the car, the trim of the car, and the configuration of the headlights.
But couldn't anyone see that? I mean, it's just, that's nothing special.
Well,
Even somebody who doesn't know much about cars could see everything you just said and say, gee, they're just the same thing.
Well, it would it was not an abuse of discretion to admit his opinion that it was the same, because he performed the analysis.
He didn't have an opinion that it was the same.
No, it's the
No,
same
no,
type
that,
of car.
right, that the class character, sorry, that the
But,
class
I mean,
characteristics
as far
were
as I can
consistent.
tell, all he said is it was a Dodge Caravan. When you clear out all the debris, it's like it was a Dodge Caravan.
That's correct, that the class characteristics were the same, which would permit an inference that it was a Dodge Caravan, which
Okay,
brings us
so
to the next
why-
piece of
I
evidence.
mean,
Okay, next piece.
Okay, go ahead.
Which is the defendant's statement, which is really the connective tissue of this case in a real way, which not only puts her with Joelle Javier all that day, but also has her driving the car all that day, with one exception where during the offer to sell the tooth back, she tells Mr. Javier to drive away in the car. Otherwise, her statement to the police is unequivocal. And she repeatedly states, and we have the transcript cites in my brief, that she was driving, she and she alone was driving her mother, Carmen Ramon's car that day. With respect to the motive evidence, and I would suggest that this motive evidence is so strong it rose to the level of intent with respect to the big and beefy fight, which was witnessed by, and was, its genesis was inferably an argument about the money still owed to the defendant by the victim, and the knocking out of her boyfriend's
But don't
tooth.
you think that whatever the call might be about that, it really was all about the tooth, right? I mean, didn't the tooth supersede the money being owed?
The tooth is certainly, right, the insults added to knocking the
Which
tooth
was
out.
it was an insult to Javier, not to her.
Well, it was her boyfriend, and it occurred in front of her, and it was touched off inferably by an argument about money owed to her, not Javier. And of course, both of
So
these
the
things-
motive is that she would be so angry about the boyfriend's being disrespected that way, and that she would take part in killing
That's
the
correct.
person who did that. That's the strong motive?
Yes.
Buddy, she'd only known for 2 months.
This,
She was
meaning
only
Javier.
dating this fellow for 2 months, right?
The evidence conflicted as to that, but yeah, it was her boyfriend, and there was evidence of their relationship afterwards, and, to sort of show the strength of that
Well,
relationship
not
was an issue.
afterwards. I mean, you can't consider that.
Well, you could
At the
consider it
time.
on the issue of whether there existed a joint venture previously. With respect to the next bit of evidence, it was her lie to police with respect to where she was at the time of the shooting. And I would suggest the jury could infer this was a manufactured alibi, this trip to Calixto's house.
Sorry, she went to Calixto's house.
She did.
Saying the call before, we're going to come see you sometime, that's part of the alibi? Is that what you're saying?
Well, the alibi, the first calls to Calixto come immediately after the tooth offer. I'm sorry, at 1 or 2, yes, immediately after the tooth offer. Then at 6:01, immediately after, even though no time had been set for her to arrive, immediately after the shooting, a call from the defendant to Calixto now is when we'd like to come over. And although the defendant's statement to police is that she arrived, and I quote from her written statement to police, a little before 6 is when she says she arrived. She in fact arrived, the best evidence, even if you would consider it in the light most favorable to the defendant, at 6:09, which is the first call that puts her within a tower in the range of 7 Cloville Avenue. That was enough time, the jury could infer, given all the evidence they had, that she could have driven from the crime scene to Calixto's
How
house.
far was the crime scene from Calixto's house?
4 miles.
4 miles at
Yes.
6 o'clock? Any indication about what traffic would be like at that point?
The traffic, from the evidence of them crossing the street, it looked fairly heavy, but
That would be
these
like
are-
that would be like if it was 5:58 when the shooting took place, she would have to get 4 miles in 11 minutes?
Yes. So with respect to
I'm sorry, you say there's a call from the defendant's phone or from her phone
from her phone to
to
her number
Calixto at what
1836.
time?
6:09.
there's
601.
6:01, minutes after the shooting.
And does Calixto
Two
say I
calls.
spoke to Mr. Javier or her?
Calixto spoke to the defendant at 6:09 ultimately. So there were two missed
I'm
calls.
sorry,
at
the
6:01,
601 call is what?
Not picked up by Calixto. And
So it's a call from defendant's phone to Calixto at 601.
correct.
Yeah, she didn't, but Mr. Javier didn't have a phone at the time, right?
Correct, correct. And the jury could have, but apparently did not draw the inference that it was. And ultimately, she admitted to police that she had called, and Calixto's testimony was that she was talking, not he, was talking to talking to Calixto in those calls, or in that call at 6:09. Now, with respect to her lie concerning not knowing the defendant's friends, I mean, this is pretty stark. The night before, she admitted she had been to Barbara Delgado's house, but she didn't say that she had gone with the defendant's friend, Yoshio Stackerman. There was also evidence that Stackerman had been to her house with the defendant before. She was the defendant's, she was Javier's boyfriend. And also the call records show Mr. Stackerman's number in her calls. So the jury could infer that that was untrue when she said she did not know the defendant's friends other than one that she named Diddy, who's actually a friend of the victim.
Was there evidence, though, also from the state trooper who said that they were operating on the belief that it was the boyfriend who was using her phone all that day?
Well, he was saying that that was possible, that they didn't definitively know, if someone was using the phone, but the jury could have inferred that the defendant was using her own phone.
Did
at that time.
she make any statements to the police? You said that she made statements to the police that she had been with the boyfriend all day and that she had been driving the car all day. Did she make any statements about whether she'd been using her own phone that day?
She made a statement, yes. She had, the call to Calixto was, in her statement, she says that was her. There was also evidence that Javier had used her phone that day. I believe there was evidence in her statement that at the Big and Beefy fight, that the call was, it was, at that point, Javier's phone was still in operation, so that was with Javier's phone.
Can I ask you, was there evidence at this trial that Javier was one of the 4 people that got out of the car?
There was, yeah, that was the Commonwealth's theory.
Was there evidence to support that theory?
Well, through the defendant's own statement, that she was with him all day, and that it was hers.
Hold on. Separate and apart from she may have been driving a car, was there evidence that Javier was one of the killers?
It was essentially the same evidence that was as to the defendant, that they were both in the area, that the cell phone tower evidence also placed, that she was with him all day, and she was definitively.
Okay, but so you're saying, well, because he was with her, he probably was one of the 4. And because she was with him, she probably was a driver. I mean, I'm just trying to figure out what's the evidence that he and these other people committed this murder, that they did it.
Yes. Well, it was largely through the evidence that it was Miss Gonzalez's van that was actually there. Her statement that she was driving that van, her statement that she was with Javier all that day. There's strong motive evidence which applied to both of them equally, I would submit, and the evidence connecting them to Stackerman that night, or the previous night.
Why is Stackerman important?
Stackerman is important because he's later linked to what was determined to be, and there was evidence that this was one of the murder weapons.
Was this admitted at this trial?
Yes.
All this came in at this trial?
Yes.
And the murder weapons were linked to him by a witness?
Well, they were, the evidence was that on the night of the shootings, Mr. Stackerman had gone to the home of his friend. He had encountered his friend's wife there. After that time, that friend was arrested for burglary. He produced a gun to police.
And did he testify at the trial?
The detective testified at the trial.
But, so this guy Medina, he's the fellow, he produced the guns to the police.
Yes,
And did he say, I got these from Stackerman?
he did not. No, he did not testify.
Well,
at the
then
trial.
how does the guns get connected to Stackerman?
Well, through that evidence that he had gone the night of the shooting to Medina's house.
And saw his wife, who said he's not here, and he went away.
Right.
Okay.
Yeah. There was no DNA evidence that connected him to that, but the evidence permitted the inference that Stackerman had dropped off the gun that night at.
How could that permit the inference that Stackerman had dropped off the gun?
Well, because the gun that was later determined to be the murder weapon was found in his house, found in Medina's house. Yes.
There was no testimony from Medina saying these guns came from Stackerman.
No.
It's just that Stackerman was once at the house, therefore probably dropped some guns off.
At the house,
So-
not
so you
just
had-
once,
You
but
had
on the
the
night of
trooper
murder.
testify, or it wasn't the trooper, the police officer who got the gun, right? That Medina gave him.
Yep.
Where was the evidence who supplied the evidence that Stackerman had come to the house?
It was his wife,
Medina's wife?
Yeah.
So
who
she
encountered him.
testified.
Yes, who encountered him that night.
And what time?
She was nonspecific as to time, but the jury could have inferred it was after the shooting.
Did she let him in?
They encountered one another at the door, and she said her husband was not there, and Stackerman said, "Tell him I'm looking for him," or something.
And so
to that
then
effect.
the inference is that he dropped off the gun with the wife?
No.
Well, how did he drop off the gun if the
Well, there was
husband
later
wasn't there?
phone contact between Stackerman and Medina that
That
would have
day?
permitted that they connected. Yes.
And you know that from call records?
From
Is that-
call records, yeah, that were admitted, that show later contacts that day, which show they ultimately connected, and
But Medina did not testify.
he did not. He did not.
Who were the other, there were two people acquitted, do I have that right?
Mr. Castro was acquitted, and Mr. Wyatt's charges were ultimately dropped.
But Stackerman wasn't one of the people that was charged with this?
He was charged and convicted, yes, Your
Oh, he
Honor.
was convicted of
Murder too, right?
Of second.
Murder,
That's right.
murder too, yes.
And
Let's assume for the moment that she was in the car and driving. What is the evidence that would support a finding beyond a reasonable doubt that when those four people left the car, she knew that their intent was to kill the victim?
Part of that involves a view of the evidence itself, which, of course, the court will do so. But they walk with purpose directly from there. The maneuver on Forest Street that has no other apparent purpose, given the fact that Forest is not a dead-end street, and then to continue along, which permit the inference that she met up with the killers near Bevel and Lynch Streets, which is where Hampton Street empties out onto.
Okay, so she knew that they were, I mean, that supports the view that she came back to retrieve them at some point in time,
Yes.
but the inference then is that she knew that when they left the car, they were going to be killing him?
Yes, because at the exact time she's turning around on Forest Street, the shooting is occurring, according to the video evidence, which permit the inference that she knew it was going to happen, given the fact that they don't meet up immediately after and discuss anything. They go directly from the car to the shooting and execute Mr. Gonzalez. And then the car goes in the direction which would bring it right to Bevel and Lynch Streets.
But how would they know that he was even in the car? They may recognize the van, but they're driving down Haverhill Street and he's on this street. You're saying they actually would have seen him in the van?
who's the they?
I'm sorry, the four people would
people?
have seen
Well, they
that
had
the victim
encountered-
was in the van, sitting in the passenger seat when he was on a side street?
Well, they had encountered the the victim in the van that very
Well,
day.
I understand that they would have said, that's his van. I get that.
Yes.
But you're saying they would have had to know that he was sitting in the van.
He was in the passenger seat of the van?
He was in the evidence was he was in the passenger seat of the van at the time. Or he was found in the passenger seat ultimately when he was shot.
And the fellow that pleaded the Fifth Amendment, what was the one who came out the back? or was trying to treat him,
Yes.
his story.
Well, he didn't testify at trial. He invoked the Fifth Amendment, and it's not a claim on appeal in the Martin hearing we're not privy to that, so we don't know the basis of his
Okay.
invocation.
Would we also have to infer that when the defendant's van stopped, that the people in the car knew that the victim was sitting in that car? Because otherwise, that it was to be a hit, having seen him in the car? I mean, are we supposed to infer that?
Well, yes.
It's one thing to say, that's his car, so he must be somewhere near there, and I guess
Right.
the other fellow lived in the apartment nearby.
Correct.
In the victim?
But it sounds as if you're suggesting that the inference would have to be that they knew that he was sitting in the passenger seat when they went out to do the hit. That she would have had to know that when they left the car.
Well, she would have had to know that that was his car, and the reasonable inference would be for the driver of the car that he was in it. I mean, they had seen him mere hours, 2 hours, or
Right, but I mean,
4
but I guess
hours
the issue
before.
is, they're driving and they say, that's his car, and they get out.
Which way was the car coming from? In other words, when when the caravan is coming towards the victim's car, is it coming towards the passenger side or the driver's side?
Well, so Hampton Street is here, and Haverhill Street runs this way.
Yeah.
The victim's car pulls over to the left on Hampton Street, which is a one-way street. Haverhill Street runs this way. When the car is stopped on Hampton Street, the defendant's car pulls over at the intersection, so drives slightly past the actual intersection, and inferably so that they could see that that was in fact the victim's car, pulls over, and then the four immediately walk directly to that the victim's car,
Walk around to the back.
then walk around to its back. Yep. And then the maneuver on Forest Street, and then later. I would submit that the circumstantial case against the defendant permit a rational jury to convict her of the crime beyond a reasonable doubt. No further questions. The rest of my brief. Thank you.